Thank you. Good afternoon, everyone, and welcome back to our afternoon's proceedings. I'd like to introduce our next speaker or start our next session, which will be the role of legal harmonization in bolstering the digital economy, the contribution of the UNCITRAL model law on electronic transferable records, and the use of cross-border recognition of identity management and trust services. Our presenter today is going to be Dr. Luca Castellani, who I will tell you is officially the godfather of Melita. And I really wish that he were here in person. Luca Castellani is a legal officer in the Secretariat of the United Nations Commission on International Trade Law. As Secretary of the UNCITRAL Working Group, he oversaw the preparation of the UNCITRAL model law on electronic transferable records, as well as the model law on the use and cross-border recognition of identity management and trust services. Right. He has assisted several countries in the enactment of UNCITRAL texts on electronic commerce. He is also active in the field of paperless trade and has contributed to drafting the framework agreement on the facilitation of cross-border paperless trade in Asia and the Pacific. Luca joins us right now from Vienna, and I'd like to kindly ask if we can unmute him so that he can go ahead with his presentation, please. The host. Luca, can you hear me? All right, well, could you all put Luca up on the screen so that we can see him and he can go ahead with his presentation? Thank you.
Thank you, Vashti, for your very kind introduction. I was a mute godfather, now I am a speaking godfather. Of course, you might also regret that, but it's a different issue. You might have preferred having me muted. So sorry not to be there with you. It would have been a wonderful opportunity to meet you all, of course, for sure next time. Sorry, we had some overlapping priorities here. So without further ado, let me please share my slides. To begin with, a very general statement about digital trade. The broader picture, of course, the whole event well organized by the Commonwealth Secretariat and, of course, the Caribbean Telecommunications Union and my thanks to both organizations and to each individual involved in this, deals with different aspects of digital trade, but not only trade, because I've seen also issues that are more of more general interest for everything that is digital. Of course, UNCITRAL deals with the commercial law, so I will have to limit my comments to digital trade. But I have to say that this is also easily done because nowadays all trade is digital. Even if we look at the informal sector or the micro enterprises, we still see that electronic communications are used in one way or the other because they are so pervasive and ubiquitous. What maybe has changed a little bit compared to the focus that we had maybe 20 years ago is 20 years ago, we were very interested in the fact that we could exchange information very rapidly and at a great distance and at very limited cost. And now we are more interested in looking at that information, which we consider data, and reusing and analyzing data. So this has, of course, changed many things in the way we look at digital trade. Every country wants to engage successfully in digital trade, but we know that there are a number of conditions. Each of them is necessary, but none of them in itself is sufficient. So first of all, we have to have coherent and I would say also decisive policy decisions where policymakers need to make the right decisions, but they also need to see them through. And this is sometimes difficult when digital trade requires, for instance, coordination of not only the private sector, but also the public sector, like the customs. Then we need a robust technical infrastructure, of course, connectivity, and this may be an issue, especially in developing countries. Let's remember, for instance, we do a lot of work in the Pacific, where many of the Commonwealth member states are located. And these countries, in some cases, they still are connected only with the satellite, which is really expensive. And that limits a lot their involvement in the global digital economy. We need to have private sector engagement because if there is no uptake of the private sector, of course, there is no trade, no digital trade, and no trade in general. And then we need to have an appropriate legal environment. And here, my main issue is to find the balance between what we call the enabling legal environment, that is to say, UNCITRAL texts which are meant to promote and facilitate, remove obstacles, and regulation. And regulation is, of course, very important, but at the same time, it also sets limits to what can and cannot be done. A typical example of regulation is consumer protection. Another typical example is data privacy. It's very important, and I have to say, Commonwealth member states have done this very well to base the law on international standards. And why is it important in digital trade? Because we want to promote technology neutrality and through technology neutrality, technical interoperability. Technology neutrality means that the parties can choose the products, technologies, and methods that they wish to use to engage in trade. And the technical interoperability means that if all the products are really technology neutral, it is possible to exchange data across applications. And we get back to what I was mentioning before about the importance of data reuse and analysis. When I talk about the use of electronic means in trade, of course, this can happen with regard, and often we talk about contract law, but sometimes we talk about dispute resolution when we have specific applications, for instance, in transport law, in banking and financing, and so on and so forth. So it is a cross-cutting issue. And in itself, if we look at digital trade law, we see different main components. I follow here a little bit the distinction of UNCTAD that has identified 4 main areas. e-transactions and e-signatures, data privacy and protection, cybercrime and consumer protection. But I would like to add right away that payments and intellectual property rights are also very relevant for digital trade. These four areas are not the same. Data privacy and protection, cybercrime and consumer protection are regulations, and they often call for a dedicated body to enforce regulation. E-transactions is actually an enabling component and does not call for any implementing agency. UNCITRAL deals with e-transactions, and that's why UNCITRAL laws do not have, they have, of course, an administering body, a minister most likely, but they don't have a dedicated agency. So e-transactions and e-signatures law, they give us the foundation for the legal recognition of the use of electronic means, and they remove the obstacles to their use. In particular, for instance, one issue that we are all familiar with is the statute of fraud, which requires the use of the written form for certain transactions because, of course, this was a safeguard for the parties. And then we ask ourselves, when we use electronic means, when do we satisfy this written form requirement? And the answer is in this e-transactions law, which apply across the board. So they apply to emails, they apply to WhatsApp, to SMS, they apply to websites, to platforms, and any other thing you can imagine. And since they are so foundational, well, at least 80% of the states have them, but I would say even more than that, maybe 90% of the states have them. And there is this global model, which is the model of UNCITRAL, which is technology neutral, as I said before, because it promotes interoperability. It applies as an add-on, so it does not change, for instance, contract law. And because it was prepared by the United Nations, it looks really at global integration and tries to take into account all legal systems and, of course, all different types of economies. And then there are regional models. And as we're talking about the Caribbean, I have to say that most, if not all, the countries have adopted UNCITRAL text, but many of them have done so through a regional model, which was prepared through ITU HIPCAR some 10 or 15 years ago. Of course, this is absolutely possible. At the same time, we also encourage to keep uniformity whenever it is possible to foster not only regional digital trade, but also global digital trade. So UNCITRAL is United Nations Commission on International Trade Law, actually the core legal body in the United Nations system for commercial law. And the idea behind is that by harmonizing international trade laws, one will reduce transaction costs related to legal lack of predictability or poor predictability. Actually, more recently, and also in the field of what we call electronic commerce, but it's really electronic transactions and trust services, we did not so much harmonize the existing ones, but we produced the laws that were actually paving the way. They were addressing emerging business needs in a uniform manner, so we would ensure harmonization from the outset. This is done by preparing treaties and model laws. UNCITRAL was actually established in 1966, so now we are going, soon it will be 60. I hope no one will say it's time to retire, however. And UNCITRAL was already working on electronic commerce in the 1980s. The use of electronic means, in particular in the beginning with regard to payments, because payments are nowadays inherently electronic, both for large sums and for small sums. And then also on something called electronic data interchange, or EDI, which was already a form of automated exchange of information in the commercial sector. What is really important is that UNCITRAL texts on e-commerce, as we're called, but really on digital trade, have been enacted all over the world in more than 100 states. And as I said, many of them are members of the Commonwealth, and I would say in particular the pioneer and the champion of these texts is Singapore. And all of these texts are available, of course, in the UNCITRAL website, in the 6 official languages of the United Nations. So these texts are the Model Law on Electronic Commerce, the Model Law on Electronic Signatures, the Electronic Communications Convention, the Model Law on Electronic Transfer Records, and the Model Law on the Use and Cross-Border Recognition of Identity Management and Trust Services. It is, of course, impossible for me to talk about all of these model laws, so I will focus on the 2 most recent ones, the Model Law on Electronic Transfer Records and the one on Identity Management and Trust Services. The Model Law on Electronic Transfer Records, and I have to say I was the secretary of the working group for the adoption of both model laws, so I was directly involved in preparing these texts. The Model Law on Electronic Transfer Records, as we call MELITA, in an affectionate manner, has attracted really significant attention lately. It is indeed an enabler of digital trade financing and also of paperless trade facilitation. So it has really these 2 streams. One has to do with access to finance, and the other one has to do with the transport. And it is also a text adopted in 2017, already taking into account these emerging technologies like blockchain, like smart contracts, like Internet of Things, and so on and so forth. So what is the core issue of MELITA? There are commercial documents and instruments that incorporate on paper the right to performance. The performance is the delivery of goods or the payment of sums of money. So you have a list here. Bills of lading, definitely, we are all familiar with them. Promissory notes as well. Checks, those who are using checks, they are of course familiar with them. Some economies, some countries, checks are quite popular, like for instance in the US. And so on and so forth. Now here, the real issue is the incorporation of the right to performance in the paper. And because who has the paper can ask the money or can ask the goods, that right is transferred with the paper. It can be transferred with the paper and with a signature on the back of the document, on the back of the paper, or it can be transferred to bearer simply with the paper itself. But the issue here is that paper is tangible. That is to say, we can touch it, we can put it in a pocket, put it in a wallet. It does exist in the real world. And of course, in the electronic environment, we cannot touch it. But since we can touch it, we have notions like possession and delivery that have to do with the physical interaction, which we don't have online. So MELITA is a model law that is enabling. That is to say, it doesn't affect regulations, but it does not introduce any regulation, which is technology neutral. We have already discussed this, how it promotes interoperability and data flows. It is built around functional equivalence rules. Now, I cannot get into the details of this, but I want to stress that the same law applies, for instance, to electronic bills of lading and to paper-based bills of lading. This is incredibly convenient because lawyers and commercial operators do not need to learn 2 different sets of laws. And they also don't need to change when the medium changes, because it is possible. Usually something is issued electronically, and then for whatever reason, it is converted to paper. But all of these stays, and what is really important for trade financing is that the rules on the use of these documents as collateral. Typically, I get financing against a bill of lading. I issue a promissory note these are all critical for access to credit. All the well-settled law in this field is not changed because of the electronic form of the document. Requirements for an ETR, I will go a bit faster here, mindful of time. The ETR has to contain all the information that is required for the paper document because the substantive law is the same. Of course, the electronic transfer record can go beyond and can contain dynamic information, smart contracts, information originating from oracles, metadata, all of these things that we have nowadays open up huge opportunities, and they are not available, of course, on paper. In order to be functionally equivalent, there is the need to use a reliable method to identify the electronic transfer record, and the means that specific electronic transfer record. Make it subject to control and retain its integrity. Retain its integrity means that it is necessary to have a record of everything that happens to the record. That's a pun, sorry, but it's really to keep a record of what happens to this electronic transfer record. These notions of these three requirements, which we refer to as singularity and control, prevent the issue of double spending. Double spending means the possibility of having in circulation two records that refer to the same performance, just like if we duplicate illegally a check, and then we would have two persons going to bank and asking for the same money. Now, as I said before, one real issue is possession. Possession finds its online equivalent in control, because control reproduces online the same features of possession in the physical world. Possession is the ability to control a thing and exclude others. And so through control, I can control the electronic transfer records, and especially I can exclude others from interfering with it. All of these will be implemented with technical service at this high level and mindful of time. I just want to say that, for instance, many have suggested to fulfill the integrity requirement with the use of blockchain, because the blockchain has this relative immutability, and everything is recorded on the blockchain. And since here we want to record everything that happens to our ETR, then blockchain could be a good solution. Now, on this one, I would like to add, we should not, however, be misled. The fact that we can record everything does not mean that we cannot record also information to the contrary. So, for instance, I can transfer a check to you, Vashti, but you, Vashti, can transfer this check back to me. And the fact that we have transferred it between the two of us will be recorded, but in the end, I will be again the holder of the check. So as I said before, all of these is meant also to prevent double spending. And here I would just like to say, we were discussing yesterday and today in the community the latest fraud on trade financing. If I recall correctly, we are talking about $560 million of nickel that disappeared from a large trader. And so someone is taking this loss. Now one can imagine these numbers, and this is not the largest fraud. Is just what was disclosed in the last few days. We have many of these. So transition to the digital environment is really imperative to avoid these issues. Of course, in order to have security, we need to implement this properly. It goes without saying. But access to trusted data and a number of controls in the system will help us to fight this issue of fraud in documentary credit. As I said before, very many members of the Commonwealth has already enacted the other UNCITRAL texts on electronic transactions, and so it is not a surprise that actually Commonwealth member states are also ahead in enacting this MLETR. Out of 7 countries in the world that have adopted it, 4 are from the Commonwealth: Belize, Kiribati, Papua New Guinea, and Singapore. And there's more in the pipeline, both in the Pacific and in the Caribbean. What is really important, and here, of course, my good friend Chris Southworth will illustrate this, is what is happening in the United Kingdom. The United Kingdom, thanks to Chris, has actually endorsed MLETR adoption at the G7 level, and now is working very quickly, I have to say, on passing electronic trade documents bill, which is based on MLETR. It is based on MLETR, but it takes into account also the specific features of English common law, and therefore it has some adjustments. This is important for 2 reasons. Of course, other Commonwealth member states may wish to adopt MLETR. They can look also at the model law itself, since they have already adopted the electronic transactions, but they also must be aware that the UK enactment is compatible and actually based on MLETR, because tomorrow you will receive in the port an electronic bill of lading issued under English law, and you have to recognize it, and you have to know this is in line with your public policy and general principles. So there's 2 sides to this, and it's really important to appreciate both sides. Adopting the law, the model law, is very good, and at the same time recognizing that documents issued under other enactments of the model law are also valid and enforceable in the jurisdiction. Now, the other text, and I will be forced to be a bit quicker as I have only 10 minutes left, is the model law on use and cross-border recognition of identity management and trust services, adopted just 6 months ago, July 2022. We call MLIT, this model law on identity management and trust services. This was actually started at the request of some EU states, because the first example of legislation in this field is the eIDAS regulation from the European Union. eIDAS has 2 parts, the one on identity management and the one on trust services. In my opinion, the identity management part is something that has more to do, if possible, with physical persons, and so often it is something that falls under Ministry of Interiors, or anyways related to civil records and vital statistics, while trust services are really services that assure quality of data. So these are really something that have to do with the digital trade and what we were discussing before. MLIT text, of course, because it was produced by UNCITRAL, refers to use in trade and trade-related services. But in reality, this is meant to be used for both commercial and non-commercial activities, in light of what I just said, that identity management actually has to do with civil records and vital statistics. In itself, it does not introduce any requirement to identify, but it actually explains how to do so based on a common set of rules. Identity is a set of attributes that uniquely distinguish a person in a particular context. So here we are talking about physical or legal person. The physical person gets one foundational identity at birth. The legal person gets one foundational identity at registration. The main objective of the model law on the identity management part is to ensure the legal recognition of the result of electronic identification. In order to understand this, one has to bear in mind that the whole identity management is made of 2 parts, the identity proofing and the electronic identification. The identity proofing is the so-called onboarding, that is to say, for instance, I get an electronic identity card. That electronic identity card in this language means I am receiving attributes that confirm my identity in a context, in many contexts, actually. And electronic identification has to do with the application of that. Now, this may look like very abstract, but in reality, we are already working on this. In the Caribbean, I very much hope that it will be possible to have the first enactment of this part of the model law, because there is a project of the Organization of the Eastern Caribbean States regarding identity management and cross-border recognition of identity management in OECS member states. And so our proposal is to leverage on this, which is something that has already been tested in the 27 European Union member states. There are two ways to define the reliability of the methods used for identity management. One is after the use and the other one is before the use. This means, for instance, that an electronic identity card can be designated as reliable by the government. But this allows also to use other ways. For instance, I can use a credit card to identify myself under certain circumstances, and it can very well be that that credit card is sufficient for the specific purpose. The model law contains also obligations of identity management service providers, but in particular also liability of service providers. It is possible, however, to limit liability. I will not get into details now for lack of time. I apologize. The second part of the MLIT has to do with trust services, and here I would just like to stress the importance of trust services for the digital economy at large. Trust services are about providing assurance of the qualities of data, of a data message. I like very much this definition, the who, what, when, where, and why of data. So who sent the message? What is in the message? Has the message been changed? When did we receive the message? Where was it received? All of these questions, very important. In reality, when the model law has some named trust services, the most important and most popular is electronic signatures. I've seen, for instance, recently, there was interest, including the Caribbean, for electronic timestamps, and there's a couple of draft laws that make reference to electronic timestamps. We can have all of these, or we can have also a more general description of trust service, because in the model law, in the MLIT, the trust service list is open-ended. The mechanism for reliability of the method and the general principles are the same, including for the obligation of the trust service providers and the liability. So I will not repeat what I said for identity management. Both for identity management and for trust services, there are rules on cross-border aspects. But here I have to say that it will not, I believe that it will be implemented in possibly in different ways, because for identity management, there is a public interest in knowing in advance which credentials are considered reliable. So for instance, in the example that I gave before, the law could say for all OECS member states, electronic identity cards issued by government are considered reliable and equivalent in each country, which means that each citizen of each state can identify herself or himself in another country by using this electronic identity card. Of course, there must be compliance with certain technical requirements, minimum technical requirements. But for trust services, in particular for electronic signatures, most of them are not declared reliable before the use. And so there will be more flexibility and many non-qualified trust services actually will be used. In itself, this model law can be used also as a template for treaties and other agreements. So to conclude, I reiterate the view that it is essential to enable data flows. This is what digital trade is about nowadays. There can be a flow of goods, there can be a flow of services, but there is also on the side a flow of data. And this calls, of course, for appropriate legal environment. And again, my fear, especially in developing countries, is that there is over-regulation. There is desire to protect the citizens, to protect the consumers, maybe also to protect small and medium-sized enterprises. But sometimes the market is not such that can accept over-regulation. And so this stifles the offer. And there is more demand than offer for these digital services. The good news is, of course, UNCITRAL texts have been very popular, and we thank states for that. And we hope that they will continue to be popular, especially in developing and least developed countries, and especially with the Commonwealth member states. And I would like to say that also the latest trends like regional trade agreements, digital economy agreements, and also Chris might have mentioned the negotiations for the joint statement initiative of the WTO are making reference to these texts, including MLETR. But I would also like to say it is not enough to adopt the law, especially in developing countries. It's really important to raise awareness and build the capacity, both of the legal stakeholders and of the private sector at large, so that they would really take advantage of this. So when one decides to allocate resources for law reform, it's also important to allocate resources for this implementation phase, which is sometimes neglected. Now, I have spoken, I believe, for more or less 35 minutes. I apologize if I had to go a bit quickly in what I said, but I hope that it was clear. And I don't know if you, Vashti, you want to ask if there is any burning question right now?
Luca, I would like to thank you so much. It is very hard for an even in-person presenter to have everyone's captivated attention after having a large Caribbean lunch. But you have managed to have us all captivated and spellbound. In this regard, I'd like to open up the floor to any questions, because I see that there are several burning questions around the table and around the room. So on that note, I can possibly take a start. In terms of your presentation, you had mentioned the use of blockchain as a possible technology that can be used as part of promoting greater assurance and transparency under MLETR. Do you have any idea of which countries, not just across the globe, are considering using this as part of their process?
Many of the users of blockchain are actually private sector service providers. And I have to say that they use blockchain in different ways. And basically none of them uses only blockchain. They put selected critical information on the blockchain, while probably the majority of the information does not go to the blockchain, because the blockchain in itself, it's expensive, and it has not only economic costs, but also environmental costs. There are examples. The most famous example of public sector use of blockchain is an ecosystem called the Trade Trust that has been deployed and is used in Singapore, which is blockchain based, and this is an ecosystem means a space where all the service providers can join, provided they meet a certain minimal standards, and one of them is to ensure that their services are interoperable, so that the data can be exchanged across service providers. But at the same time, this is actually promoted by government. by Singapore's IMDA, which is the agency in charge of promoting information and communications technology use. So they believe in it, and they are continuing to use it also for live transactions, and it's under development. I believe that more generally, blockchain had a big phase of hype, and now is hitting the so-called plateau, of disillusion, and then it will go towards actual use uh, for the things that it is useful for. It's not the solution to all problems, but in certain cases, like what I mentioned before, it can be useful. I really believe it will be a bit like what happened for PKIs in the 1980s. Some people were saying PKIs will be used all the time. They are used a lot, but not all the time.
I see a few hands around the room. I believe the Permanent Secretary of the Ministry of the Attorney General has a question for you. From Trinidad.
Good afternoon, everyone. Hello? Yes. Good afternoon. No, I just wanted to find out whether or not, we have a lot of issues with capacity in our ministry as well as in Trinidad and Tobago. And I was just wondering whether or not do you all offer training or capacity building in the areas of international e-commerce laws and that kind of thing. So I was just wondering if you all have any kind of set programs or whether or not that would be available to other countries.
Thank you. Thank you very much. UNCITRAL does that kind of work to a limited extent because it is a small organization. It's part of the United Nations Secretariat Office of Legal Affairs. But luckily, we can rest on the shoulders of giants. Of course, the Commonwealth Secretariat is one strong partner to organize this kind of activities. But both the Commonwealth and UNCITRAL are partners in the E-Trade for All initiative, which is coordinated by UNCTAD. And UNCTAD has a specific training, both online and in person, including on legal aspects. So typically a request that is sent to us, we can discuss with UNCTAD, but even better is sent to UNCTAD and is discussed with us. And of course, we cooperate in preparing the materials when they deal with UNCITRAL texts. Right now, there is an online course on identity management, which actually is aimed especially at small islands. And this can also be delivered in person, of course. UNCTAD really has the funds, and we can arrange a coordinated action with their help because they have the money, they also have the expertise on the delivery, both remotely and in person. But of course, we come in to make sure that you have some lawyer who would tell you something very boring and very legal that all the lawyers like. So we make sure that we participate.
I am sure that they will be calling upon you and take up your offer. On that, I have a question from Owais.
Yeah, thank you very much for a wonderful presentation. My name is Mohammad Owais Khan, and I work at the Commonwealth Secretariat. Maybe my question is not related to the current presentation, but as it is accepted that regulatory impact analysis is one of the most important tools for good regulations. So is UNCITRAL doing anything or regulatory impact analysis, or do you have any templates for that? Or you're working in some countries providing some kind of technical assistance or something?
We don't deal with regulation. We deal with the effects of regulation in sometimes. And here I would like also to reply to a question that we have in the chat, which is would I suggest are the main issues that force the market to reject regulation? UNCITRAL is on the side of private sector typically because commercial law applies to business transactions. As such, our guiding light is, of course, freedom of contract and party autonomy, which means the parties are free to decide the content of their contracts. In the digital trade space, this means that the parties are free, as I said before, to choose whatever software or method or application they like to. At the same time, of course, there is regulation to some extent or the other. A lot of the regulation has to do, for instance, with import-export. So we interface with the national single windows. We do good work, especially in Asia and the Pacific, to create an enabling environment for paperless trade. But for instance, with regard to MLETR, as I mentioned before, there's a lot of regulation for financial instruments that would apply, regardless of the fact that these are on paper or in electronic form. I must say, the real issues here, and I'm giving, I'm going a bit out of my comfort zone, but what I hear a lot is overregulation for data privacy and protection. That creates real problems to private sector. But at the same time, for certain states, they consider this a human right, and so it's more difficult to deal with that. And I would like to say also one has to see things in a broader perspective. The states that think that regulation is good, they don't want to enable too much cross-border data flows. And the states that they think regulation is bad, they want to enable cross-border data flows. And why? Because those who want to enable, they have larger data processors, and the other ones have not. So if data gives a strategic advantage, then one can see where this is going. So I believe that the issue of regulation, again, I insist this is not my field, but it is an issue that requires some really deep thinking from the policy side, because it's not just the impact of existing or possible future regulation, but really it has some strategic implications.
Thank you, Luca. We have a question from Chris Southworth.
Hi, Luca. How are you doing? I was giving you a good plug earlier on, so I hope lots of people are going to email you after this. I know you've got lots of time to answer the emails. Luca's kind of the main person, I have to say. We're very lucky to have him here, supporting the whole kind of global environment around this Melita drive. Just to support what, it wasn't really a question for you, Luca, it's more just to answer some of the questions on regulation and data. I think we've got to be clear here, we're talking about B2B data. We're not talking about B2C in the transactional space. This is commercial trade information that's already available on paper. All we're talking about is putting that into the digital realm. So there are lots of concerns around data from both companies and governments, but a lot of it is over-egged because we're not talking about any personal data that's not already existing. We're not talking about any different way of transacting. We're just talking about transacting in a digital environment. I think that's a really important point. But in terms of implementing Melita, it's really important to talk to the financial regulators, and if you have them, information regulators. Because the last thing we want is to do a fantastic piece of legislation and then the regulators say, no, we're not going to accept information in digital form. So getting them warmed up is one area where the government can really, really help, because coming from the commercial sector, that's obviously very difficult for lots of different reasons. It's one of our asks that I should have put on my list, actually, in terms of a call to action, is to engage those regulators and make sure they're on board. It shouldn't be controversial what we're asking here. I hope that's helpful.
It's very helpful. Do we have any other questions across the room? All right. On that note, I'd like to thank you so much, Luca. And I wish you a wonderful evening, and thank you so much for taking the time to join us today.
Thank you. Thank you for inviting me. Thank you very much.
So it is my distinct pleasure to introduce to you today the very last speaker. There's this statement, save the best for last, and I was saving our own there, Mohammed Awais Khan, who is our advisor for regulatory, the cluster at the Commonwealth Secretariat, Commonwealth Connectivity Agenda. I'm sure that you've all seen Awais waving his timekeeping flag around for the entire past day, but he is actually a man of many talents. He also has a lot of knowledge to impart in relation to international trade agreements, which is what he's going to expound upon today. So I invite you to the podium, Awais. All yours. Oh.
Thank you very much, Vasti. I hand over these to you.
Thank you.
I think, well, thank you very much, and good afternoon, ladies and gentlemen. It is a huge pleasure and great honor for me to share with you this platform today. Before I start my presentation, I would like to thank Chris for setting the stage for my presentation by giving a very, very comprehensive presentation on paperless trade and public-private partnership. So those were two important aspects which are also important for trade facilitation. But before I formally start my presentation, can you tell me how many of you have actually interacted with customs authorities? How many of you have been involved in imports or exports? Okay, so we have a gentleman here. So you must be very much aware how much time consuming it is, how much resources it requires to comply with custom procedures, to provide all the sanitary and phytosanitary bill, the laboratory test and other things. So that adversely affect on the competitiveness of SMEs. Your question that you posed to Chris. So these are the issues, but we are not going to talk about the issues. We are going to talk about solutions, and that would be the crux of my presentation. So the topic is international perspective, trade facilitation agreement, and international cooperation. My name is Mohammed Awais Khan, and I work at the Commonwealth Secretariat. The outline is that I'll speak a little bit about Commonwealth Connectivity Agenda, then some facts about Caribbean, which I can skip because you are all from Caribbean and you know about the fact that the regional trade agreements to which Caribbean countries are part, and preferential trade agreements, trade facilitation index, WTO trade facilitation agreement, CARICOM, case studies and way forward. I was asked by the organizer to crack some jokes here and there because after lunch, but I don't know a lot of jokes, so that to keep you awake. I myself feel a little bit sleepy. I don't know who is going to keep me awake. But I don't mind. Taking a small nap is not a bad thing. Not a bad thing at all. It keeps, it stops you from getting to old age, particularly when you are driving a car. So in my presentation, you can take a nap, but be aware and be sure that you don't disturb the person on your right and left who is also taking a nap. So there's MFN principle. Everybody can take a nap. Commonwealth Connectivity Agenda. In 2018, the CHOGM, which is the apex body at the Commonwealth Secretariat, they decided that there is a need to augment trade and investment within the Commonwealth countries, and they set a target of $2 trillion intra-Commonwealth trade by 2030. And that could be achieved by improvement regulatory regime across the Commonwealth countries, creating enabling business environment, and developing participatory regulatory reform. So these were the three areas to focus at to advance trade within Commonwealth countries. But pre-COVID, there was a survey, there was an assessment that Commonwealth country need to create 50,000 jobs per day to provide jobs to the young people who are entering the labor market.
And that becomes 17.5 million new jobs to be created each year till 2030 against 12 million which were provided annually from 2003 to 2016. So what to do for employment creation, new investment, and to facilitate trade flows and to facilitate regional integration and regulatory integration. The response could be augment trade and investment among member countries. They should do more trade among the member countries, ensure that there is transparency and predictability of laws, of rules, regulations, fees, that how your investment and your trade is going to be treated when you trade or invest across the border. Harmonize and standardize legal and procedural requirements, address trade barriers. You all know about all these things, so I don't want to go into details of this. Promote public-private partnerships, because public sector alone cannot do anything. They don't have the requisite knowledge and expertise that the problem and issues that the private sector can face. And the private sector cannot influence the policy making without their involvement in the dialogue process. So public-private partnership is very much important. Expedite and simplify clearance procedures. You develop a very good product. You use all the digital technology. You use all the digital technology in its development, its production, its marketing. But when it goes to the customs and they cross the border, there are so many hurdles at the border. So those needs to be addressed. Develop regional value chains, foster digital economy with a view to boosting economic growth and innovation, and promote regional and intergovernmental cooperation. The focus today would be, we'll just touch upon World Trade Organization Trade Facilitation Agreement, the CARICOM, the TFA is multilateral, CARICOM regional one, EU CARIFORM, EPA, and then OECS. Okay, so these are some facts about Caribbean and Latin America, the GNI, population, poverty, main exports, main imports, what are the challenges, what are the opportunities. I don't think that I know better than you. You are well conversant with all those things, so I can skip this to save time. The PTAs, which have already been announced to the WTO, I have provided links. So if someone is interested in going into more details, there has been early announcement of Canada CARICOM, then the CARICOM, EU CARIFORUM states, and United Kingdom CARIFORUM states. Those have already been announced to WTO, and for Canada, it's early announcement. So maybe it's in the process of negotiation. These are some of the non-reciprocal preferential trade agreements which are provided to the Caribbean countries. Some, in addition to these, some are available to the LDC member countries, which I haven't captured over here. But this shows that how much is the scope, how much you can export by developing regional value chain, investment, promotion, and trade promotion. The Trade Facilitation Index, and here I think there is a need to focus more because if we look at the figures, those are some of them are good, but most of them are not very promising, so there is a need to work on it. Information availability, involvement of trade community in decision making, in regulatory reform and other things. Advanced ruling system, some of the countries do not have advanced ruling system at all. What are the appeal procedure, fees and charges, documents required, and automation procedures. So I think there is a need to work on trade facilitation, how to improve it. Then WTO, TFA. The main objectives are to expedite movement, release, and clearance of goods. Improve cooperation between customs and other authorities, both within the country and outside the country, and enhance technical assistance and build capacity. So these are the three stated objectives of TFA. And WTO, TFA, within the agreement, there are approximately 35 technical measures which impose obligation of WTO members to increase transparency, to improve governance, and to implement, streamline, and modernize border procedures so that the traded goods pass the border smoothly and enhance the movement of goods in transit. There are special and differential treatment for LDCs and developing country members, and they were required to notify in 3 categories all the measures: category 1, A, B, and C. So, okay, that will come in a later slide, that how many they have notified to the WTO. So the TF measures about transparency and appeal that all the information should be available. They should be published. They should be published and available on internet so that the SMEs and other trading community, they have access to that information. Establishment of inquiry points for trade information. The private sector and stakeholders have the opportunity to comment, and there should be consultation, advance ruling. I just would read them because if we go into details, it will take maybe a few days, not 30 minutes. And then for transit, there are restrictions on fees and charges, use of guarantees instead of paying all the amount, and then import, export, transit and fees and formalities, discipline, there are discipline, it provides disciplines on fees, pre-arrival processing that the goods have been dispatched, not arrived at the border post, but you submit the documents and they are processed, risk management, post-clearing audit, published, and these are single windows. So these are the measures which are provided in the TFA agreement, and if these are complied with and implemented, will definitely improve the trade across the border. So these are the TFA commitments that I was talking about. So some of the countries, they have notified 37% like Antigua and Barbuda in category A, then Barbados, Belize, Dominica, Grenada. So they notified in category A, B, and C. Category C is those which they will not implement without technical assistance. Category B, for which they have a transition period to implement, and category A, which they implement immediately, but with a grace period. So CARICOM, I was very pleased when I saw the regional trade facilitation strategy, and I think this is not the final version of the presentation. Anyway, it was approved in 2017 by CARICOM for implementation, and it identified that there is a potential for regional trade, because CARICOM within the region, it's only 12% of trade, as opposed to Asia and Europe, where these figures are quite high. Then it identified that there should be reduced intra-regional trade cost. If there is a regional trade strategy, TF strategy, it encourages productive synergies and strengthens regional value chains. It increases regions' attractiveness for new investment and makes it competitive. Mainstreaming regional best practices, identifies and address key regional trade constraints. Okay, so this was approved by the 45th meeting of the CARICOM Council for Trade and Economic Development in 2017. It identified regional strategy. It provides regional strategy for TFA implementation, and they have identified 18 priority category C measures for implementation, and 5 target priority areas, which are transparency provision within the agreement, test procedures, the lab test, and others, single window, how to establish single windows in different countries, and maybe at the CARICOM level, risk management, post-clearance audit. And the implementation modalities are that they provide regional support for national implementation and regional support to implementation. So these are the 2 modalities. Regional support for national implementation, they have developed model laws as far as legal is concerned, so that could be adopted by the member countries. And they have provided administrative operational support, model harmonized SOPs models, and harmonized forms and documents guidelines for establishment, operation of national administrative bodies. They have been organizing regional seminars for capacity building of public and private sectors, and regional coordination among the member countries by creating regional committees to monitor and support the national implementation. The regional approach to implementation is that they implement regional and or sub-regional trade information website. I don't know if that has been, because I checked, couldn't find it, maybe. And then the strategy also provides for establishment of regional trade information inquiry point, because the traders, the businessmen, they usually find it difficult to get information about the market, about exporting, about duties and other things. About the SPS and TBT requirements, the NTMs. So they want to establish one regional trade information inquiry point, establish regional risk management system and data exchange, and establish regional advanced rolling unit. So these are some of the initiatives that they wanted to take at the regional level, which could benefit all the member countries. Okay, EU CARIFORUM Cooperation, they provided support on standards equivalency. CARICOM and Dominican Republic were one of the examples mentioned by them. Work on standards legislation is one other area where they're providing assistance. And then member states supported for adoption of regional standards, regional standardization procedure, and modernized and regional priorities being elaborated. The OECS, they have integrated border system, a maritime single window for goods as well as for passengers. I think the gentleman, his agency Impact is responsible for that. So, and they have the dual border system, one for the custom union member and one for the others. Okay, here are some of the case studies, and I provided the links. So if you are interested in reading more about these case studies and how these countries and these regional cooperation agreements have supported their business communities, you can click on that and get more information. But the first one is the Asian-wide self-certification mechanism, where the registered the scheme enabled a certified exporter to self-certify the origin of the goods without going into and visiting different offices to get the certificate of origin. He can certify it himself. It eliminates the need to apply for a certificate of origin or ATIGA Form D. So this again, like, is a support to the business community that they can digitally verify the origin of the goods. Then the other one again is from ASEAN. It's ASEAN Solution for Investment Services and Trade. The link is there for more information, but this is a consultative platform for expedited and effective solution of operational issues related to the implementation of ASEAN preferential agreements. And this regional information portal available for enterprises from ASEAN, and it covers tariff and non-tariff measures, cross-border services, and measures limiting investment. The ASEAN single window, which is the portal, the link is available. It enables exchange of trade-related documents, such as ASEAN customs, declaration documents, electronic phytosanitary certificate, and electronic animal health certificate. So these are the certificates which could be electronically available and presented. The next one again is ASEAN Trade Repository, an electronic platform for the public access of regulatory and tariff information of and other trade relevant information. It enhances transparency on trade and customs laws and procedures of ASEAN member countries. The East African countries, one-stop border posts, they plan to have 15, 13 were established. I believe the other two would have been established by now, but here is the link and you can go into more detail, and it promotes simplification of controls at borders through a one-time check at the border between two countries. Instead of have multiple checks, one-time checks enables it. And then East African countries regional trade information portal, again, it is an electronic platform which outlining step-by-step guidance on licenses, pre-clearance permits, and clearance formalities for the most traded goods within, to, and from the ESC. The Trade Facilitation Index, they also have their Trade Facilitation Index, but it is so far internal, could be used by the authorities of the member countries, and it is not in public domain at the moment. Then SACU's regional customs policy. Again, it is a framework for implementing a regional customs cooperation strategy. I believe I'm now falling asleep, so I need to keep you awake and wake up myself as well. So I don't know any joke, but you can just smile so that the organizers think that I have cracked a joke. Okay, so this is the SACU's regional customs policy. Again, a very detailed one, and you can, if you are interested, you can go into more detail, and it provides a framework for implementing a regional customs cooperation strategy and coordinates modernization effort for identifying regional cooperation priorities. I think I should, yeah, the last slide. So I think I was quick, huh? What? You told me to finish in 20 minutes, and I didn't see any flag from your side.
I am very, very, very impressed. So on that note, I'd just like to open up.
No, not open. This. I'll just go through it in half a minute.
This was.
This is the last slide. So the way forward is institutionalized stakeholder engagement at the regional level. At the regional level, this was a joke, okay? Yeah, thank you very much for laughing. Yeah, so this is the institutionalized stakeholder engagement at the regional level. Identify the most relevant stakeholder, get together with them, discuss with them, and reform. Then mainstream regional best practices. For instance, Barbados has done some very good thing. You can just emulate that in your own country. Implement the regional trade TF strategy. CARICOM, excellent strategy, and I believe that its implementation would also be handled in a very professional and excellent manner. Fully implement and resource the Regional Trade Facilitation Committee. Adopt common benchmark and harmonize performance indicators at regional level. That will help. And then integrate and digitalization of custom procedures. Centralize the communication with donor agencies, because without technical assistance, you cannot implement the Category C measures. So negotiate with them, take technical assistance, and implement those things in your countries and at regional level. Communicate and learn from other international best practices, as you saw the case studies from ASEAN, from SACU, from ESC, and many other. So World Bank is doing very good work. UNSCAP is doing very good work, particularly on paperless trade in Mongolia and other regions. So just read these, and maybe you can emulate them. Digitize information, communication, and border procedures. That will help, because it is important for SMEs. The big enterprises, they don't have so many problems because they are resourceful. They have resources, both monetary and as well as technical, as well as financial. So it is the SMEs. So facilitate them, and if all these things are online available, it will enhance their competitiveness, and augment coordination, cooperation among custom authorities of the member countries, as well as coordination among different authorities within the state. So this brings us to the conclusion of this presentation. Vashti, I'm really sorry if I overrun the allocated time, but I finished. So the floor is with you now. Over to you.
Are you sure that you are done?
Yeah, I believe it's finished, yes. Okay, finished.
All right, so now I can open up the floor
So
for any.
I go there? Or?
No, do we have
Yes.
any questions from the audience?
Yes, Chris. Yeah, but you told me that we are going to take questions together. And now you are on the other side of the table. You are asking questions.
So here's a question for you. We've talked about the need for the digitalization of commercial trade documents. You and I spoke earlier on about the WTO Trade Facilitation Agreement, sort of really focusing on customs digitalization. You know, from a business perspective, we're actually really happy with the progress on customs and trade digitalization, trade facilitation. Actually, there's a lot of great work, and the case studies up here, fantastic, top drawer. The question now is: every country has a national trade facilitation committee.
Exactly.
So we've got a public-private partnership mechanism sitting right in front of us. Why aren't we just expanding the remit of those, the terms of reference of those committees, to now incorporate the digitalization of commercial trade documents? And if there's a reason why that can't happen, what's the reason why it can't happen? Because the lesson since the WTO Trade Facilitation Agreement is fantastic work, but it hasn't led to the outcome that we were hoping, which is the transformation of the trade ecosystem. The lesson learned is we now need to be more holistic and actually cover that commercial space too. So why aren't we using those trade facilitation committees? It seems like a gift horse looking right in front of us that we're not really using.
Just to share with you a few examples from my previous work, when I was working at Nepal as ITC representative over there. So we established NTFC over there. We developed TORs for that. We developed the framework for that. We developed the regulatory legal framework, because you need to institutionalize the NTFC, because otherwise if the technicals goes away, the communities are finished. So we provided all that support to Nepal. Same was the case in Pakistan, where we provided support in TFA negotiations and categorization of category A, B, and C measures. The problem is that in many countries, I'll not name anyone, but some, as per my research when I conducted before coming for this presentation, NTFCs were developed by different countries, but they are not operational the way it was desired. So there is a lack of sustainability, I would say. So there is a need to regulate it, to institutionalize it, and then at regional level, I think there is a need to have those a committee comprising of those NTFCs, so that the regional level should intervention should be in line with the country level intervention, and the country level intervention should be in line with the regional level interventions.
Okay, in the best interest of time, I'm going to we're going to take one more question. And this is from our remote audience, who have been submitting quite a few. But one of them is, what's next? And how are we assuring coherence, navigating and managing the pivotal points of interoperability?
The pivotal point of?
Of interoperability.
Interoperability.
Yes.
And the question is from?
Good question.
Yeah, question is a very good one. Yeah, but who asked the question?
How?
Okay, whoever, but as I mentioned in my previous response.
Jamaica.
Yeah, that the way forward is that the regional approach should be strengthened. The TF strategy is there, a very comprehensive one, very good work done by CARICOM, but if that is implemented in its true spirit, I believe it can create a good environment for the business community at the regional level. So there is a need to strengthen the Trade Facilitation Committee, resource that committee at the regional level, and if there is funds and resources constraint, I think there are many donors available and working in the field, particularly World Bank, particularly the TFA facility and others. There are so many UNCTAD, they can provide support to implement that regional TF strategy.
Yeah, if I can just jump in quickly on that. There's one area where we are slightly concerned, but there's also an opportunity, is single trade windows. You know, we're seeing a lot of those proliferate around the world in various different forms, and this is linking now to the standards piece that we were talking about earlier on. In a worst case scenario, is we're trying to simplify trade, make it cheaper, faster, simpler, everything else. The worst case scenario is here we have 180 single trade windows that don't talk to each other. And there's a real risk of that happening. And learning the lessons that I flagged up earlier on with TradeLens, with WeTrade and other technology platforms that have fallen away, the ask from business is really to make sure that we're embedding that standards toolkit, the standards set out in that framework, into the design of the single trade windows. If we do that, then we're building interoperability in from the outset. What we don't want to do is have to re-engineer it into the system, which would be infinitely harder, obviously. And what we definitely don't want is lots of single trade windows being launched and then not talking to the other single trade window on the other side of the transaction chain. It's just repeating the same mistake that we know is already there. It's not actually not adding any value. It's just creating another problem, another complexity. So that's the kind of ask from business, is please make sure that those single trade windows are designing in the standards from the toolkit. Come with us, join us, support us, and then the system will be okay in the longer run.
Thank me before I say.
Thank you very much, Louise.